Okay, so I think our numbers have stabilized now. So good afternoon, everyone. Today's webinar is a webinar that we're running in collaboration with Legal Network Wales and Legal Network London, which is a free referral and support network for law firms run by Hugh James. The network has assisted hundreds of law firms to retain their clients by offering expert legal advice in areas that they do not practice in, or are unable to do so due to conflict. Now, in return, the network can offer a fee share and a commitment that Hugh James will not poach, cross-sell, or market their services to the referred clients. And if that's something that you'd like to know more about, please make a comment, indicate that on the feedback questionnaire that will pop up for you at the end of this webinar. Now, very briefly, just by way of introduction to the speakers, your first speaker is going to be myself, so Natasha Dzameh. I'm a commercial and chancery barrister and mediator at St John's. And what I'll be talking about is setting aside a trustee's appointment for undue influence by reference to the case of MacKay and Wesley. You'll then hear from Sarah Bolt, who is a senior associate at Hugh James in the Contested Wills, Trust and Estates team in London. And she's a specialist focusing on cross-border and charity legacy disputes. She will be talking about the case of Gosden and another in Halliwell, Landau and another. And then finally, you'll hear from Leslie Blohm, QC, who is also a commercial and chancery barrister and mediator at St John's. But he also happens to be the head of the commercial and chancery team and the winner of the Chancery Silk of the Year award at the Chambers Bar Awards in 2019. He'll be speaking to you about interpretation of wills by reference to the case of Knipe and British Racing Drivers Motorsport Charity and others. Now, to crack on with the first webinar, so my topic, which is MacKay and Wesley. I have simplified the facts a little bit just to make this slightly more digestible for the purpose of the webinar. So just to give you a quick summary of those, essentially, well, before we start actually, the reference that you'll have for this case on the advertisement is the reference for the decision at appellate level. The first instance decision, however, was reported, and if you need the reference for that, it's 2020 EWHC 1215. Now, insofar as the facts are concerned, what had happened in this case was that MacKay had signed the deed of appointment and agreed to indemnify outgoing trustees. Her father, who was Wesley, and a law firm had been appointed as trustees also. Now, she alleged that she had been subjected to undue influence. She said her father had a strong and controlling personality and she was suffering from ill health, and so she did not understand the effect of what she was signing. Now, prior to her appointment, the trust had engaged in a CGT avoidance scheme. Mauritian trustees had been appointed and gains had been realised in Mauritius where there was in fact no CGT. The proceeds were distributed and UK resident trustees were then appointed in the same UK tax year of assessment. Now, the reason for the last step, or the reason why it was necessary, was because the appointment of UK resident trustees within the same year of assessment would exclude the operation of Section 86 of the Taxation of Chargeable Gains Tax Act 1992, which essentially required the trustees to remain non-resident throughout the relevant year in order for it to apply. Now, if Section 86 applied, the gains would have been attributed to the defendant as the UK settlor of the settlement or of the bulk of its assets, and so the scheme would have failed to avoid the payment of CGT. Now, there's no material before the court to indicate that the appointment of the UK resident trustees was not a necessary step in the scheme, and there's a case that sets out, or where the court determines the necessity of that, which is a case called Smallwood and HMRC, which is 2010 EWCA Civ 778. Now, in this case, the current case, MacKay and Wesley, the potential CGT liability, if the gains were realised or the settlement's assets were applied in such a way as to give rise to liability for UK CGT, was around £1 million. So obviously they were quite keen to avoid having to pay that. Now, MacKay was appointed on the 19th of March 2003, and when she was appointed, the value of the trust was £61,000 instead of £3.6 million. So unsurprisingly, HMRC challenged the scheme. Now, it turned out that Wesley was impecunious, and the law firm itself had gone into administration, which left MacKay responsible for the tax liability under Section 65 of the Taxation of Chargeable Gains Act 1992. And 16 years essentially went by before MacKay applied to set the appointment aside, during which the residue of the trust fund was paid or distributed, and various of the trust documents had been executed by her. And the first instance decision was heard by Deputy Master Henderson, and she had relied on Non-Effectum lack of capacity, mistake, and undue influence. Now, the Deputy Master rejected all 4 grounds and stated that even if the requirements for rescission had been established, he would not have ordered it. He said it wasn't satisfied that such an order would operate justly and fairly. So if we take each of these elements in turn and have a look at the court's findings. Now, firstly, non-effectum is something that you generally run as a defence. It's available to someone who's been misled into signing a document that's essentially different to the document that they intended to execute. So the person who's claiming that must show that the document signed is fundamentally different to the one that they intended to sign, and that they were not imprudent or negligent. And that sort of plea does require the court to consider extrinsic evidence. Now, insofar as the findings are concerned in that respect, MacKay had not believed the document she was signing was fundamentally or radically different in character from the document she thought she was signing. She knew that the document related to offshore trusts, and simply not realising that she was accepting liability for a large potential debt did not mean that she was sufficiently mistaken as to the deed's fundamental nature for non-effectum to apply. The focus, in fact, is the effect of the deed in appointing her as a trustee, not the consequences of the appointment. Now, insofar as capacity is concerned, the court said, well, a contractual transaction entered into by someone lacking capacity to make it is voidable at the instance of the incapacitated party if the other party knew that they lacked capacity. But by contrast, a voluntary transaction entered into without capacity is void. The court said, well, the deed was a contract, not a unilateral voluntary transaction. In consideration of the new trustees being appointed, they covenanted to indemnify the Mauritian trustees. There was no evidence that the Mauritian trustees knew of any lack of capacity, so even if MacKay had lacked capacity to enter into the deed, it would not be void or voidable. And in fact, there was no medical evidence of lack of capacity. So then we move on to mistake. Well, MacKay's appointment as trustee was affected unilaterally by the outgoing Mauritian trustees, not by her. And this was referred to as the unilateral act point. The court said there was no indication that they had been mistaken and that MacKay need not accept the appointment for it to be effective. Rescission for mistake applied to non-contractual voluntary dispositions. The appointment was not a disposition of property by MacKay. The appointment was not voluntary. She gave consideration, so it was outside the scope of the equitable principle. Now, MacKay's assumption in executing the deed that she was not in danger of incurring a liability was not a sufficiently distinct mistake for the principle to apply. It was insufficient for MacKay to have a general belief that the transaction would not have an adverse effect. MacKay was not seeking rescission of the whole deed, only her appointment. And so that raised another issue, which is simply the court said, well, partial rescission of a contract cannot occur. It has to be rescinded as a whole. So then the court was left with the issue of undue influence. Now, most, if not all of you will be aware that undue influence is something that arises where a relationship exists between two parties, where there is trust and confidence, reliance, dependence, or vulnerability on the one hand, and ascendancy, domination, or control on the other. That's Ettridge. Now, in terms of the findings here, the court said the transaction whereby MacKay became a trustee was one that called for an explanation. Wesley knew the appointment was part of a tax avoidance scheme and should have considered the possibility that it would not work, there being consequences for the trustees. MacKay was not given advice before executing the deed and had been vulnerable. If the transaction had been bilateral, so between MacKay and Wesley, the court would have set it aside for undue influence, but it was not a bilateral transaction. MacKay also had only sought to set aside her appointment, and 16 years had passed before she applied to do so. So what the court then looked at as well was the issue of justice and fairness. The court said, well, if the entire deed is set aside, the tax avoidance scheme fails, and the evidence hadn't addressed the consequences of that. If MacKay's appointment were set aside, HMRC would be unable to seek a contribution from her, and the court could not be satisfied that either order would not operate unfairly or unjustly. Permission to appeal was sought. That permission was refused by Deputy Master Henderson, but permitted subsequently by Justice Trower, who also in fact granted permission to MacKay to amend her pleadings. And the amendment was permitted on the basis that the essential substance of the argument was going to remain the same, even if the new perspective was conceptually distinct. So what happened on appeal? Well, the appeal was heard by Mr. Justice Mead, and MacKay had at this point dropped the non-effectum and lack of capacity arguments. her pleadings were amended to make clear that what she sought to set aside was in fact her acceptance of her appointment under the deed. So looking at the unilateral act and undue influence point, the court here said, well, even if the master was correct, so that acceptance of the appointment was not necessary for a person to become a trustee, and that the appointment was not effective until disclaimed, it didn't stand in the way of MacKay asking the court to set aside her acceptance. Her acceptance was a unilateral act by her, resulting from undue influence. But in any event, Justice Mead disagreed with the master for a number of reasons. And so firstly, Section 36 of the Trustee Act 1925 said only referred to the appointer's ability to appoint a new trustee. It was neutral as to the effect that had prior to acceptance by the intended appointee. Secondly, the idea of disclaimer. So looking at the phrase disclaimer, that might have a connotation of undoing something that has occurred, but it's too weak an indication to be relied on in itself, so to say that someone has to disclaim. Thirdly, the master had relied on a case called Mallet and Wilson, but that was a case primarily about whether a settlement bound the settled property or failed when a trustee disclaimed it. It was not about the precise status of the intended trustee prior to disclaimer, and it had been doubted in a case called Re Abacus Limited. And then finally, Justice Mead said, well, the duties that came with being a trustee were central and included the duty to get in and safeguard the trust property. An intended trustee could not have those duties imposed upon them, even provisionally, without knowledge and consent. Now, as to the idea of partial rescission, it said that insofar as the master asserted that the principle of partial rescission of contracts prevented rescission of MacKay's trusteeship under the deed, he was wrong. In the case of Kennedy, it was stated that there's no reason why that limitation should apply to a self-contained and severable part of a non-contractual voluntary transaction. Now, Kennedy did not intend rescission to be refused purely because the original wording on the document signed by the parties would be different in legal effect from that which followed the rescission. This would preclude the removal of the clause in question in that case, and would in fact also prevent partial rescission from occurring in any case. Now, MacKay and the other new trustees have been identified separately in the deed. If she were no longer a trustee, nothing else in the deed would in fact need adjusting or would cease to make sense. So her acceptance of her appointment was a self-contained and severable part of the deed, which was liable to be rescinded for undue influence. As to the idea of the fairness of rescission, the court said, well, neither injustice nor unfairness would be caused to Wesley or the law firm, which is in liquidation, if the rescission occurred. And so on that basis, rescission was permitted. So the case of MacKay and Wesley is quite a useful case in terms of just looking at how not only undue influence operates, but also just giving you an introductory guide really to non-effectum, at least in the first instance decision. But it does outline as well for you in a bit more detail quite what the roles are when someone is being appointed, and the idea that you can't simply have that appointment foisted upon you. Now, the cases that I referred to, I'm aware that I haven't given out any notes, but you will have the reference for the appellate level case, and I've given you the reference for the first instance decision. All the cases that were referred to, the references are contained within those two cases. So that's why I haven't set those out. But hopefully you found that to be a relatively useful summary of the position. And now I'll hand you over to Sarah Bolt to speak to you about Gosden.
I'm just checking that everybody can see my shared screen before I start. Tash or Leslie, could you confirm for me?
Yep, that's fine, Sarah.
Perfect. Brilliant. So I'm talking today about the case of Gosden and Halliwell Landau, which was decided earlier in 2021. I'm a senior associate over at Hugh James, based out of the London office in the contested trust, will and probate team. If there are any questions, we're going to take them at the end after Leslie's presentation as well. So the case of Gosden, we're going to go through the case background, the disposal of the property, the High Court decision in 2019, and then the Court of Appeal decision in 2021. So in summary, Mrs. Wendell owns a property in Kennington, London. In April 2003, Mrs. Wendell entered into an estate protection scheme to reduce liability for inheritance tax. If she had sought to leave that property under the terms of a will, the rate of inheritance tax would have been greater than what was due under the estate protection scheme. The property was effectively placed in trust, and Mrs. Wendell remained the legal owner, and Mrs. Wendell, Mr. Gosden, her son, and Miss Kay, being Mr. Gosden's wife, were the trustees. Under the terms of the estate protection scheme, Mrs. Wendell enjoyed the property during her lifetime, but it was to pass to her son on her death. Until then, she was not able to dispose of the property without the consent of all the trustees. Her solicitors, who were Halliwell Landau at the time, later becoming Halliwell's, and its ex-partner Philip Laidlow, were instructed to complete the relevant paperwork but failed to enter the restriction against the registered title. So where did it all go wrong? In 2010, Mrs. Wendell entered into a civil partnership and left the bulk of her estate to her new partner, Miss Cook. In October 2010, in breach of trust and without the consent or knowledge of any of the trustees, Mrs. Wendell sold her property for $875,000. Mrs. Wendell died in April 2013. It wasn't until 2015 that the trustees found out that the property had been sold. In 2019, when the High Court decided the matter, His Honour Judge Pelling said it was common ground that, but for the failure to register, the estate protection scheme would have been effective and the property would have passed to her son on Mrs. Wendell's death in 2013. In his original ruling, the court held that solicitors had been negligent, but the claimants had not established that this has caused them any loss because if they had approached by Mrs. Wendell, the High Court felt that consent to the sale would have been given. The claimants, being the trustees, insisted that they would not have given consent to the sale throughout the course of the proceedings, and the question of whether the mother could have persuaded them did not arise. Their concerns were quite deep-rooted about Mrs. Wendell's ability to marry, and there was a deep-rooted mistrust about Miss Cook and her potentially influencing Mrs. Wendell. The Court of Appeal decision came back before the courts in February of this year. In that, Lord Justice Patten overturned the decision and ruled that causation and damages were to be approached on the basis that if the restriction had been properly registered, no sale would have taken place. In that decision, he stated that the only realistic and proper conclusion available to the judge was that the claimants would not have consented to the sale. The judge was therefore wrong, in his view, to have held that the defendant's negligence had not caused the claimants any damage. The main issue between the parties came down to the question of damages. In law, the default position is that damages should be determined at the date the wrongful act occurs, or in tort, the date at which the loss caused by that breach of duty occurs. In this case, this is arguable because was it when the date of when the loss crystallised back in April 2003 when the solicitors should have registered the restriction? Was it at the date of the sale of the property in 2010? Or was it at the date of Mrs. Wendell's death in 2013? This is all important because the values of the properties differed over the years. So in 2010, the property was valued, valued at $785,000. In 2013, when the property at the date of Mrs. Wendell's death, it had increased to $875,000. At the date when the claim was issued in 2017, the property was valued at $1.25 million. The claimants argued that the court can and indeed should depart from the default position where it needs to in order to adequately compensate Mr. Gosden. The claimants sought to argue that damages should be assessed as at the date of trial, in this case being at least 1.25 million for the value of the property. The defendants argued to the contrary, that the default rule should apply, but if there is a departure from the default position, then it should only be as far as when Mrs. Weddell passed away in 2013. The Court of Appeal decided to depart from the usual rule and adopt the date of Mrs. Weddell's death as the appropriate date of assessment, as this is when the estate protection scheme clearly meant to take effect. It was when the date of the true loss occurred. It held that if Mr. Gosden would have been assessed at an earlier date, he would have been undercompensated for his damages, and if a date of trial was used, he would have been overcompensated. In terms of quantum, this meant that a figure of around 1 million was agreed for damages. This included the rate of interest applicable and was based on a figure agreed between the parties following the Court of Appeal's conclusions. The loss was calculated as at 2013, the date of death, when the property was worth 875,000. In addition to that, the court also said that it was reasonably foreseeable that Mr. Gosden would have retained the property for some years to generate rental income. In considering the damages, the court also stated the amount of inheritance tax payable by the estate would also have to be deducted from the award. Damages were assessed as from the date of death of the deceased in 2013. They were assessed on a conventional rather than loss of chance basis. So coming on to the conclusion and a whistle-stop tour through the case, the claimant was overall awarded for the damages for the loss of property in 2013. So the value of the property was 875,000. There is no universal rule when it comes to ascertaining the date for assessment in negligence cases overall. The court in this case held that it was reasonably foreseeable to account for rental income that Mr. Gosden would have retained the property for some years. This came to a total figure of around £1 million. A separate cost ruling is expected shortly, and it's expected to be at least 6 figures and heavily disputed. In cases like this, there's often a lot of concern when there is a departure from a default position, as it can create some uncertainty. But if you read through the whole case and the reasoning of the judges that were involved, there is clear reasoning in this case as to why they felt the only way to compensate the claimant was to alter the default position. When appropriate, as in this case, the courts will determine limitation and the date of loss differently. Although the negligent act by the solicitors occurred all the way back in 2003, the appropriate date in this case was to look for when the date was crystallised and when the deceased passed away for the loss. And invariably, this case will be used to help claimants argue for a higher level of damages in the future. So that is everything from me, and I am just going to unshare and pass over to Leslie.
Thanks very much, and thank you very much for that, Sarah. Right, I'm going to be talking about will construction and the fairly recent case in the High Court in Bristol of Knipe and the British Motor Racing Drivers Club decision of His Honour Judge Matthews. So before I do that, or as I do it, I'll see if I can get the technology to work and see if I can share some of my notes up on the screen, PowerPoint. Right. Do you all have it? Sarah, can you tell me?
I can see it, so I hope everyone else can.
Right, okay, good. Right, okay. let's get to the start. Right. You might think it's a slightly odd topic to be talking about interpretation of wills by reference to a specific case, because if there's one thing that all chancery lawyers, whatever, will know, it's that we interpret documents by reference to principles and not by reference to specific facts. So one decision on a particular document is not authoritative guidance for the interpretation of another will, another document. One has to look at each document on its own facts. But the case of Knipe is quite interesting for a number of reasons. First of all, because it shows an extremely experienced and knowledgeable chancery judge, His Honour Judge Matthews, looking at a really black letter process of interpretation of a document, which is of assistance to all of us. Secondly, it deals with it in a fairly short ambit. The judgment is short, and therefore you can look back at it and see whether you agree with the judge's approach or not. Thirdly, it looks at some specific aspects of the case, in particular when extrinsic evidence and to what extent extrinsic evidence is available, and also the difference between a gift to an institution and a gift for the purposes of the institution. Excuse me. And the practical consequences that can have as far as the gift is concerned. And lastly, it tells us something about the procedure that we ought to adopt, can adopt, the court can adopt, in respect of these sorts of contested or indeed non-contested disputes about the interpretation of wills. So the will itself and the surrounding facts. The deceased was a gentleman, Mr. Barry Williams, and he executed the will in question on the 26th of February 2004. He died in 2018. The estate was a substantial one, been valued at in excess of £1 million. And as we shall see, the dispute related to the interpretation of the gift of the residuary estate, which formed the substantial bulk of Mr. Williams' assets. He made some bequests, but most of his money went into residue, and most of it was immediately accessible and distributable, although part of the property was subject to a life interest. So a fair bit worth arguing over, you might think. There were two problems, as I say. One was interpretation. What did the residuary bequests under the will actually mean? And the second was procedural. How should the court go about deciding what, in years gone by, would have been a multi-handed chancery punch-up with leading counsel and juniors for all parties arguing over the fine points of interpretation of a less than clear piece of legal drafting, with the consequential effect that that would have had on the value of the estate once the lawyers had all taken their bites out of it. Okay, let's have a look at the will itself and the terms. And I may come back to this in the course of this talk, but worthwhile looking at it straight away. So, 4 gifts. First, 50% of the revenue of the residue went to the British Racing Drivers Club Benevolent Fund. 30% to the British Racing Drivers Club absolutely, with a request the money be used for the Barry Williams Scholarship Fund to be set up for aspiring racing drivers. Thirdly, 10% for the Royal Society for the Prevention of Cruelty to Animals. And lastly, 10% for the Cancer Research Fund. and the disputes arose over the true meaning of clauses A and D. Now, before passing on, I'll just make a couple of, I'm sure, fairly basic points. The first is that as far as clause 8b is concerned, this is what's known as a precatory gift. So although a purpose is cited, there's no obligation on the part of the donee to use the money for that purpose. In terms of the British Racing Drivers Club, which, as I understand it, is a association which, amongst other things, owns the Silverstone racing circuit and whose membership comprises many famous motor racers and drivers, can basically do with the money what they like. They don't have to set up a scholarship in Mr. Williams' memory or for that purpose, but he simply wanted them to do so. And that may be material when we come to look at the nature of the gifts. So what problems did we have? Well, first of all, clause 8a. The first problem is that no such named institution as the British Racing Drivers Club Benevolent Fund existed. The British Racing Drivers Club itself existed, but since about 2002, it had administered the British Racing Drivers Club Motorsport Charity. Now, as luck or fate or design would have it, that is in fact a benevolent fund which looks after those who are connected with motorsport and who are in need, which is in many ways the definition of a benevolent fund. What's also material is the date. It was set up in 2002. We know the will was executed in 2004. So, first question that arose, how are we going to decide, how's the court going to decide who should receive half of the residue of the estate worth approximately £500,000? Well, His Honour Judge Matthews considered that this was fairly straightforward. He referred, first of all, to the extrinsic evidence in support of the application. And I'll just pause here to mention what I mean by extrinsic evidence. Extrinsic evidence is evidence simply relating to facts outside of the will. Now, there is only one sort of extrinsic evidence that parties aren't entitled to look at when construing a will, and that is some evidence of the testator's subjective intention. As a matter of course, you can't look at that. There's one exception. So what's the one exception? Well, if you have an ambiguity on the will, then if you can apply section 21 of the Administration of Justice Act 1982, the court does have power to look at the subjective evidence of the testator. So if we had a document in which the testator had written to somebody, I intend that by this gift the money goes to X, or similar wording, then in those circumstances you could look at that document and have regard to it in deciding what he meant. Makes things fairly easy. There was a problem in this case, and that was that where you would expect to find that sort of evidence, which is the will file under which the will had been created, had, as the judge put it, unfortunately been destroyed. Now, we don't know how it came to be destroyed. One hopes that the solicitor who drew the will had asked Mr. Williams whether he wanted the will file, and Mr. Williams had instructed him to destroy it. If that hadn't happened and it had been destroyed in some other way, that would be unfortunate, but the judgment, besides saying it's unfortunate, doesn't tell us how that might have come about. But the consequence of that was that the court simply had the other extrinsic evidence to look at. And what was that? Well, it was evidence that in his youth, Mr. Williams had been quite a proficient motor racer himself, and that he had been, and was at the date of his death, a member of the British Racing Drivers Club. So armed with that, His Honour Judge Matthews said, well, this is a straightforward example of how you construe a gift in a will, and he applied the principles set out by the Supreme Court in the well-known case of Marley and Rawlings. And he said, well, it was clearly intended by the testator that the identity of the beneficiary be the Motor Racing Drivers Club's charity. So in other words, it was intended to go to that particular body, and that was the conclusion that he reached. Now, the outcome, I think, is perfectly clear and straightforward and right. But there is a wrinkle here that I think you ought to be aware of. I said at the outset that there's a distinction between making a gift to an institution and making a gift to a purpose. And sometimes those are difficult to distinguish. Now, normally it doesn't make any difference. And here it probably also didn't make a difference as far as clause 8A was concerned. But I think it might have a difference when one looks at the other problem. I'll come on to that in a moment, but let's just go back and see exactly what the distinction was. I think the point to start really is here, that Marley and Rawlings tells us that we construe wills the same way we construe any other document, which is that we look at the document and we're trying to work out what the maker meant by the words. Sorry about that. The consequence of that is that you can always look at extrinsic evidence other than evidence of the intention of the testator when you're trying to construe a document. Now, if we look at the wording of clause 8A, it was a gift to the British Racing Drivers Club Benevolent Fund. Now, it seems to me likely that that was actually meant to be a gift to the British Racing Drivers Club's Benevolent Fund. In other words, to the purpose of the charitable fund, which was held by the British Motor Racing Drivers Club. Note also that under clause 8B, the club got money absolutely for its own use. And in contrast to that, under 8A, I think, the testator intended to give the money to the club for the purpose of its charitable use. And you might be thinking by now, that's a chancery lawyer finding a distinction where really none matters. I don't think the outcome should be any different here under this clause, but it might be under the next one. So let's go and have a look at that. Now remember, under clause 8D, the gift was to the Cancer Research Fund. The problem was that no such fund existed as at 2018. There was no evidence that the deceased had any particular connection with any particular fund, so hadn't given money, it seems, or not been affected in communications with a particular fund. So what was the position? Well, Judge Matthews held that he hadn't contemplated giving the money to any particular institution, but instead had intended that the gift be for the general purpose of alleviating cancer for the purposes of a cancer research fund. He said, well, alternatively, if I'm wrong in that, the identity of the institution isn't critical to the gift. This is a gift made with general charitable intent. And so by virtue of the fact that the gift itself may fail, it follows that on any analysis, said the judge, the executors could apply that share, which is 10% of the residue, by advancing it to any such charitable fund. And two of the defendants to the application were similar sounding charities. So the judge said if the executors want to advance the money to either of those funds or both of them, then that would be satisfaction with the bequest. Now, I think there are some problems or difficulties with that particular analysis. And it's really this, that if you look back at the various bequests under Clause 8, 8D wasn't the only fund that was being referred to. 8A was a fund as well. And according to the judge, if you were looking at 8A, there was a gift to a specific institution. Well, under 8A, the beneficiaries were all capitalised and definitive. It was the British Motor Racing Drivers Club fund. In the same way, under 8D, it's the Cancer Research Fund. That would appear to indicate, if the judge is right, that if A was a gift to an institution, so was D. Well, what's the consequence of that? Well, the consequence would be that if the gift was intended to be for a specific institution and none was in existence as at the date of the death, then the gift would potentially fail unless it was saved by virtue of there being a general charitable intent. Well, why would there be a general charitable intent here? The judge said, well, there are other charitable gifts in Clause 8, but Clause 8 did not contain exclusively charitable gifts. We know that 8B, for example, was an absolute gift as well as a charitable gift. Now, what's the upshot of all of this? Well, the upshot seems to me to be this, that the judge came to the conclusion that he couldn't say which specific institution was intended as the beneficiary. And he said, well, in those circumstances, you treat it as being, as if it were, you treat it as being a general charitable gift. I have my doubts about that. I think that if the position is that you conclude that the testator intended a specific gift to an institution, but you just don't know which institution it is, then the gift fails absolutely. And in those circumstances, the consequence would have been that the gift would have passed to the other parties who were interested in residue. Now, why was it that the judge felt that he could deal with matters in the reasonably short way that he did? Well, what was critical to this application here was that the parties who were listed all agreed as to the outcome of the hearing, but there was a problem. Executors won't rely on the say-so of named parties. And what happens if somebody else pops up and says, well, actually, I'm the charity that should have benefited? If the executor has paid out his money on the basis of an agreement with somebody else, he may still be liable to that third party if the third party has a good claim. So the executor needs some help from the court. The fact that all the parties before the court agreed with the outcome, again, didn't help, because the court won't make a declaration by consent. Parties can agree between themselves, but if they agree, there's no dispute. If there's no dispute, the court in general won't make an order litigating it. So you need to start a claim. It needs to be in some way contested. Well, here, the defendants had not filed any response. They weren't contesting it. And a Part 8 claim, which essentially this is, doesn't give you any way of entering judgment in default. You've got to go to court and you've got to get a response. So what the judge did, and clearly he was asked to do, the application was made, was to deal with this by way of summary judgment. And a summary judgment, that procedure as a matter of construction, is available if, and this is the practical test, if the issue is regarded as a short matter of construction and all the relevant evidence is before the court. The judge was plainly satisfied that all the relevant evidence was before the court, and he regarded it as a short matter of construction. The fact that I've been able to look at points, and I look at points and say, well, I think this is more difficult than that, probably doesn't bring it outside what an experienced Chancery and Trust judge would regard as a short matter of construction. So the point is, if you can go forward with uniformity, this is a way for executors to get the matter dealt with relatively shortly. Well, why were there not 5 people turning up mob-handed to argue this summary judgment application? The answer was undoubtedly that behind the scenes, the parties had reached some sort of broad agreement themselves as to how matters were going to be dealt with, and that's the way they acted accordingly, and that's very sensible. What I also found particularly interesting was that, in fact, the hearing was not a hearing at all. It was a hearing which the court determined without a hearing under CPR 23.8. Judge Matthews decided that he could answer the case with the benefit of the evidence put in front of him without calling the parties before him. And the judgment that you see reported in Bailey is a judgment that's given without the parties being present and ending with them having 7 days to apply to set it aside if they want to. I've got no doubt that no one would have applied to set that judgment aside. A, it's certainly correct, and B, it's what everyone who was present wanted. For those of you who have these sorts of difficulties of construction, it may be, particularly in these COVID era times when we're all looking for ways not to have court hearings and to deal with matters quickly and cheaply, it's a way forward to see if the court will assist in effect and give a decision without anyone turning up. But you're only going to do this if all the parties to the litigation can agree at the outset. Otherwise, well, it's back to the traditional argument, get the lawyers out and have your full dispute. I hope that's going to give you some ideas for litigating these disputes a little more effectively and efficiently in the future, and we'll see whether the Knipe is cited in future cases or procedural disputes. Thanks very much, and Sarah, I will hand back to you.
Fantastic. It's now the opportunity to ask myself and speakers Leslie and Natasha any questions that you might have. I believe that we're doing that by way of the question and answer forum at the bottom of the screen, which you can type in your questions. I haven't got any at the moment, but by way of a reminder, Natasha spoke about setting aside trust appointments for reasons of undue influence. I've spoken about Gosden and Halliwell Landau, which was a professional negligence claim, and Leslie's just spoken about the interpretation of wills under the Knipe case that we've just heard. So if there is anything, please feel free to type in and let us know. Otherwise, we can pass around the slides after this is finished, and we can take any questions directly as well. I'll wait a few minutes just to see if anything comes through.
While we're just
Nothing
waiting.
so far.
No, there they go. We're both talking at the same time. While we're just waiting to see if anyone does have any questions or whether they've been stunned into silence. I just wonder, Sarah and Natasha, whether you think that Marleyan rulings has really changed very much in terms of will construction. I mean, I know at the time, 2015, it was marked as being a significant change in approach by assimilating wills to other documents. I rather get the feeling that the profession has rather shrugged after that, and that it hasn't changed in practice. It hasn't changed the approach at all, which either means that we were getting things right beforehand, or that everyone has assimilated to it so easily it's not caused any problems at all. What do you think?
I remember at the time that it came out thinking, oh, this is going to make a huge difference. But then actually I find that when I'm writing opinions, it hasn't really fundamentally changed my approach. So I would be inclined to agree with you that we were all doing it correctly before, but that might be quite big-headed of us all.
Yeah, I mean, Knipe's unusual in that it actually cites Marleyan rulings, but I know a lot of the cases where they've been where Marleyan rulings have been mentioned has in effect gone through a series. It's yes, this is the test, and now we deal with construction, which is where we always dealt with it. So yeah, I think things have certainly calmed down rather in the profession thereafter.
Okay, well, we haven't got any questions through, so I think it's probably the right stage to wrap things up. As I say, slides will be circulated following the end of this presentation. If there are any questions for Leslie, Natasha and I, please feel free to contact us directly. Otherwise, thank you all very much for attending. It's been great to have you along.